All right, so let's get this show on the road. The first lecture in this course is really an introduction to the law and legal systems, and it's designed to provide you with an overview of the topic that we're going to be studying for the next few weeks. Each lecture is going to include some learning objectives. I'm not going to read them to you, but you will see them in the PDF handouts, and you will see them here. But like I said, I generally probably won't read those to you, but they're there for your reference. And I hope that you do take me up on the PDFs that I'm providing for you so that you can just kind of copy along or take notes along with my slides. So what is law? Law is really, according to Black's Law Dictionary, a body of rules of action or conduct prescribed by controlling authority and having binding legal force. That which must be obeyed and followed by citizens subject to sanctions or legal consequence is a law. And really, we need laws to keep society civil. Law is what gives us guardrails to help us know how we should and should not behave. In business, it helps to make business predictable. If I have a contract, I know what my relationship is going to look like. If I am an airline and I know that I have to operate within the guidelines of FAA authority, I know that my competitors have to operate within the same guidelines, so we're all on an even playing field. And so really the law helps to make things predictable and keep us civil. The role of law in society is really about power and importance. Power because the reach of the law touches nearly everything that we do. Everyone is influenced and will be affected by the law. Maybe when you woke up this morning, you had one of these, you had the alarm set. Well, Apple created this little dandy product. And when it did, it was so innovative that it got patents. The patents that helped to create the success of Apple's iPhone are protected by intellectual property law. Maybe when you got up, you turned on your television and you started watching maybe the local news, or maybe. But if you turn on your TV or your computer and you watch the news, what television networks produce has to be within the confines of the Federal Communications Commission, the FCC. There are certain words that you can't say, there are certain things that you can't do, and so the FCC governs all of that. When maybe you hopped in your car and you drove to campus or you drove to work. Well, when you do that, you have to abide by the rules of the road, the speed law. Okay, you can't speed, you have to stop at red lights, that kind of thing. When you get to campus, you have to follow the policies and procedures set forth by MiraCosta College. If you park in a staff parking lot, you're getting a ticket, okay? If you stand up in class and start screaming obscenities, the student services folks are going to want to reach out to you because we have rules about what you can and can't do in class. And so, like I said, the law is everywhere around us. We don't see it, but we are impacted by it. And the law is important because every society with a historical record has had some system of laws to govern them. Jurisprudence is the philosophy of law. When we look at law, what we find is that you have a lens that you see the law with. And that lens is jurisprudence. So I'm going to talk about a couple of philosophies of law. There's a few more, but I'm going to hit on the main important ones. So first of all is legal positivism. And legal positivism basically says that law is what the sovereign says it is. The sovereign, back in the day, would have been the king or the queen. But now when we're talking about legal positivism, we're talking about the recognized political power for whom citizens obey, the government, the president, whatever you want to think it is. And so really there's no room for questions of morality if you're looking through a legal positivism lens. If the government says something is illegal, then you are not supposed to do it. If the government says something is legal, then you can. Okay? So legal positivism, if the authority says it's not allowable, then it's against the law. Natural law is based on the work of Thomas Aquinas. And basically, under natural law, there is a philosophy that an unjust law is no law at all. And so the fundamental rule with natural law is you have to do good and promote good, and evil is to be avoided. If you think about the work of Dr. Martin Luther King and the civil rights movement, the folks in the civil rights movement, those warriors for freedom, were arrested because what they were doing was against the law at the time, against the sovereign. Okay, sovereign said, you know, that there were certain things that that people of color could not do. Sit in the front of the bus, for example. And so Rosa Parks, when she sat in the back of the bus, she was violating that law according to legal positivism, but using a natural law philosophy. What she and other folks in the movement were saying was, we shouldn't have to follow that law because it's unjust. And so that's natural law. Legal realism is probably the law, the theory of jurisprudence that most of us interact with on a regular basis, because that's really about who enforces the law counts more than what is in the writing of the law. And so what that means really is that personal biases influence our legal decision making. Let's say that you are speeding on your way to campus and you get pulled over by a police officer. That police officer really has a choice of whether or not to give you a ticket, right? He pulled you over for speeding, but he might let you go. And his decision to let you go is really about legal realism. Maybe you remind him of his daughter. And so he's going to let you off with a warning and let you go on your way. Maybe you remind him of his daughter's bratty friend who he doesn't care for very much. In that case, you're getting the ticket. That's legal realism. Moving on to sources and categories of U.S. law, the U.S. Constitution is our main source of law. It is the law of the land. The U.S. Constitution creates our government. It outlines our three branches of government, the executive, the legislative, and the judicial branch. I will talk more about those in the Constitution lecture. It creates a system of checks and balances among those branches, and what that means is no branch of government has more power than the other. They have different roles. So Congress is not more powerful than the president. They just have different roles. The Supreme Court is not more powerful than Congress or the president. They have a different role. And in addition to the three branches of government, the Constitution also guarantees basic rights to the American people through the Bill of Rights. Again, I will talk about those in a different lecture. Additional sources of U.S. law. Statutes are laws that are created by legislative bodies. Federally, we have Congress, who creates federal statutes. Locally in California, we have the California State Assembly that creates California state statutes. And California also has an executive branch, by the way, which is the governor's office. And then administrative law is administered by administrative agencies who enforce statutes that are created by Congress. Your local congressman, even though he has the ability to govern, for example, air travel in the United States, he doesn't have the experience or probably the time to be up in the control tower at Lindbergh Field. And so what Congress does is they create administrative agencies who then can carry out laws. So the Federal Aviation Administration, the Federal Communications Commission, Environmental Protection Agency. Locally, the California DMV is also an administrative agency. So administrative agencies exist everywhere at the state and local level. And then treaties are created by the US president with foreign nations. And so a treaty is a set of laws that are created by the president and a negotiating team, or the president's representative. A lot of times it's the Secretary of State, with foreign nations. But the thing with treaties is that they have to be approved by Congress. If the president negotiates a treaty and Congress doesn't approve it, that treaty does not become US law. Another important source of US law is common law. And common law is what we call judge-made law. And basically, what happens with judge-made law is that legal decisions are made based on prior legal decisions. There's a principle that this is based on called stare decisis, which means let the decision stand. And here's what happens with common law. Let's say that I have a dispute with MiraCosta College, and I think that I have been discriminated against. I've been treated unfairly. Maybe I've been terminated for a reason that I think is wrong. So I go and I speak to an employment lawyer. What the employment lawyer is going to do is he's going to take a look, or they are going to take a look at prior cases that have very similar circumstances to mine. And that will tell them what my chances of success are. And so that law that is based on prior cases or precedent helps to enable attorneys to determine whether or not I have a case, which then helps them tell me whether or not I should move forward with my case. When new law is created through common law, it creates new precedent. In order to do that, you actually have to have something unique about the case. That makes it a little bit different. And that happens in the appellate process. I will talk more about that in another lecture. But common law, huge source of US law, and a lot of the law that we're going to be looking at in this class is common law. Looking at classifications of law, civil law and criminal law are probably the two biggest areas of law that predominate in our society. Civil law regulates rights and duties between parties. Contracts, how you interact with MiraCosta College, things like that. Criminal law is law that governs behavior that is so egregious that society has really said we can't tolerate this. And so criminal law is an area of law on its own, which we will talk about. Again, this is an overview lecture, which we will talk about in its own lecture, and I will get more into the nuances and the facets of criminal law at that point. Within law, and I'm going to use the speeding ticket example to help explain this. There is substantive law and procedural law. Substantive law is conduct-based, meaning that you're supposed to do something or you are prohibited from doing something. And then procedural law is process-based, meaning the procedures that people are supposed to follow in adjudicating or following the law. So for example, that officer that pulls you over for speeding, there is a substantive piece and there is a procedural piece. The substantive piece is, were you speeding? The procedural piece is, did the officer file the ticket on time? Did he put all the correct information on the ticket? Did he do everything that he was supposed to do in order to process that ticket according to California state guidelines? If he didn't follow all of the procedures, that excuses you from culpability. If you prove that you were not speeding, that also excuses you from culpability. So when you think about a speeding ticket, it's not just the substantive piece that you may have the ability to argue against, it's also the procedural piece. And that's the substantive law versus procedural law. In looking at legal and political systems, we generally see law based in three different ways. Many legal and political societies are based on common law, which is based on precedent. The United States and the United Kingdom both are based on this concept of common law, where most things fall on precedent. Civil law systems are based on civil codes. So contracts, for example, which in the United States is predominantly covered by common law, in a civil law-based society, those laws guiding contracts are based on civil codes. Most of the Western world outside of the United Kingdom has a civil law-based society where you have these civil codes that govern a lot of the legal environment. And then in some societies, they have religious-based law, which is based on religious texts. So in lots of parts of the Middle East is based on Sharia law, which is law that is based on religious text. Also, Indonesia is probably the largest country that is based on religious-based law. Moving on, last topic of this lecture is case analysis. Because you're going to be looking at some cases in this class, I want you to understand what's going on when you see a case. So let's take an example of my Sharp v. Maricosta College case. The plaintiff is the person who is suing. So that in this case would be Sharp. The person who is suing may also be called the petitioner in some types of cases. Family law, a lot of times it's the petitioner. The defendant is the party who's being sued, may also be called the respondent in some jurisdictions. Again, family law, it would be the respondent. And then the issue is the legal question that's being decided. It could be an issue based on contracts. It could be a criminal issue, whatever it might be. And then the holding is the decision of the court. The holding is really what the court decided, okay, the statement of the decision. All right, so that's the end of the first lecture. Congratulations, you made it. A couple of things I want you to think about, and I want you to think about this for every lecture. I'll put this reminder up most of the time. What did you learn? What will you take away from the lecture? I want you to think beyond the topic. And what can you apply to your life? That's going to be really important in your lecture notes each week. What did you learn? What are the takeaways? And what can you apply to your life? My goal in this class is that you can apply something from each lecture to your life. Maybe it was about speeding. Maybe it was about maybe it was about the idea that an unjust law shouldn't be followed. Whatever it was, I'm really curious as to what you get out of these lectures, and you should always get something out of the lecture. If you're not getting something out of the lecture, I'm not doing my job, and you need to tell me that. So that's it for lecture number 1.